Our attention now to this story about the former acting Speaker of Parliament, Lechesa Tsenoli, today arguing virtually before the Constitutional Court against a High Court judgment which found sections of Parliament's impeachment rules relating to the process of removing the public protector unconstitutional. Ayesha Ismail following that story, joining us now live from our Cape Town studios. Ayesha, good afternoon. Thank you very much for joining us. What's been happening in court so far in this matter?
So, Dan, you will recall that this matter that's being heard in the Constitutional Court as we speak, it started at 10 o'clock this morning. It speaks about the details of the removal of a Section 9 institution head, and we're talking here about the Public Protector. Now, our Public Protector's fitness to hold office is being called into question, or rather has been called into question, and this follows a number of questionable rulings and findings made by her. Parliament then made a decision that they would set up a panel to investigate or to see whether there's evidence to hold an inquiry into her fitness to hold office. Parliament set up this panel, and this panel was led by a retired judge. So what happened was that the Public Protector, to put it very simply, went to the Western Cape High Court to go and challenge this panel being led by this retired High Court judge, because basically what she was saying is she was talking about the separation of powers, and this is what the Western Cape High Court ruled, where they ruled in her favour on two issues. One, on the question that this panel was set up by, or rather was led by, a High Court judge, and secondly, the fact that while she was allowed to have a legal representatives, she had to speak for herself. She could not have her legal representative speak for her. And coming back to the panel being led by a retired judge, it talks about the separation of powers, the separation between the judiciary and the legislature. And the reason why this matter has now landed up in the Constitutional Court is because Parliament, as well as the Democratic Alliance, are saying that they want this matter to be heard on an urgent basis. They don't want to go to the Supreme Court of Appeal because they believe that the matter will inevitably land up in the Constitutional Court, and they believe that this is a constitutional matter, and at the end of the day it is the Constitutional Court that's going to have to rule on this matter. So they've gone for direct access. They're applying for direct access to the Constitutional Court. On the other hand, Advocate Darling Mpofu, who is acting for the Public Protector, is saying that the legal representatives for Parliament and the DA did not make out a case for urgency. He's saying there's nothing stopping them from going to the Supreme Court of Appeal, and for the Supreme Court of Appeal to hear this matter first. And he's saying that there is no urgency. And this matter is now still being heard in the Constitutional Court. And as I said earlier, the legal representatives for Parliament and for the DA, they're saying that this matter is, it's a matter of public interest, and it has to be heard as soon as possible. Okay. We'll hear later today whether these arguments will continue on another day, and how soon a ruling will be made on this crucial issue of separation of powers.
Thank you very much, Ayesha Ismail, for that update. For now, we'll have to wait and see what the outcome will be, as she says.